Good morning and welcome to the 10th meeting of the Equalities and Human Rights Committee. The only item on our agenda today is Stage 2 consideration of the Civil Partnership Scotland Bill. Joining the committee today is Cabinet Secretary for Social Security and Older People, Shirley-Ann Somerville, and her officials. Welcome to you all. This morning will work well if we all take it slow and steady. When I call you to speak, please pause before speaking to allow your microphone to be switched on. Everyone should have a copy of the bill as introduced, the marshalled list of amendments which sets out the amendments in the order which in which they will be disposed of, and the groupings. There will be one debate on each group of amendments. I will call the member who lodged the first amendment in that group to speak to and move the amendment, and to speak to all the other amendments in that group. I remind members who have not lodged amendments in the group but who wish to speak, they should request to speak by typing R in the Blue Jeans chat function. Please do this once I've called the relevant group, and please only speak when I call your name. I would ask anyone speaking to be succinct and to make sure their contributions are relevant to the amendment or amendments being debated. Standing orders give any Scottish Minister a right to speak on any amendments. I will therefore invite the Cabinet Secretary to contribute to the debate just before I move to the winding up speech. The debate on the group will be concluded by me inviting the member who moved the first amendment in the group to wind up. Following debate on each group, I will check whether the member who moved the first amendment in the group wishes to press it to a vote or to withdraw it. If they wish to press ahead, I'll put the question on that amendment. If a member wishes to withdraw their amendment after it's been moved, they must seek the committee's agreement to do so. If any committee member objects, the committee immediately moves to a vote on the amendment. If any member does not want to move their amendment when called, they should say not moved. Please note that any other MSP may move such an amendment. If no one moves the amendment, I will immediately call the next amendment on the marshalled list. Only committee members are eligible to vote, and voting will also take place in the Blue Jeans chat function. Once I've read out the result of the vote, should you consider your vote has been incorrectly recorded, then please let me know immediately. I will pause to provide time for this. If we lose connection to any member or to the Cabinet Secretary, I will suspend the meeting until we reconnect. Again, short, succinct contributions are strongly encouraged for all those speaking today. And we'll now begin Stage 2 proceedings. Working from the marshalled list of amendments. The question is that sections 1 and 2 and Schedule 1 be agreed to. Are we all agreed? Anyone who disagrees should type in the chat function. We are agreed. Now move on to section 3, and I call amendment 1 in the name of Alex Cole-Hamilton, grouped with amendment 2. Can I invite Alex Cole-Hamilton to move Amendment 1 and speak to both amendments in the group? Alex.
Thank you, Convener. Good morning, colleagues. And I move Amendment 1 in my name. Amendment 1 deals with an issue raised at Stage 1. Section 3 of the bill provides for an interim period. Mixed-sex civil partnerships registered out with Scotland will be temporarily treated in Scots law as if they were marriages. This is to provide couples with legal protections between the commencement of Stage 3 and the commencement of the rest of the bill. Section 3 rather. Once the whole bill is commenced, those civil partnerships will be treated in law as civil partnerships and will continue to have the legal protections under the then expanded civil partnership law. Martin Lote of the Equal Civil Partnerships campaign, who came to see our committee, explained to the committee that this is problematic because people in his situation have specifically chosen to register a civil partnership instead of marrying. This is a campaign that was hard fought and hard won. He urged that the provision be reconsidered, or at least that the interim period for which Section 3 operates be kept to a minimal. Again, he cited the fact that people in his situation had campaigned to have equal civil partnerships because of the baggage that's attached to marriage in many different ways. Other witnesses at Stage 1 also felt that the provision impinged on people's personal choices. There was a concern that mixed-sex civil partners, if they came to Scotland during the interim period, would find that they were told that they were in fact married here. However, the committee recognised that there is no immediate alternative to the general approach taken by Section 3. We looked at this from several angles, and if we want to provide such civil partners with legal protection as soon as possible. Cabinet Secretary reassured the committee that such couples who come to Scotland could still say they were in a civil partnership, and she was very committed to exploring ways of improving the language of Section 3, and I am grateful to her for working with me on this. And she also committed to look what could be done to speed up the necessary secondary legislation and commencement of the whole bill, so that the interim period is as short as possible. It would be good to hear an update on that from the Cabinet Secretary in her remarks. Amendment 1 addresses some of the concerns raised. It makes clear that although legal protections are provided during the interim period by law, treating the civil partnership as if it were a marriage, this does not prevent the partners from presenting themselves as civil partners and not married. I think this is really as good as we can make it, convener. If they had to complete an application form, for example, on insurance, they were asked their relationships status, it still answer civil partnership. The amendment gives reassurance to people in this situation that they will not find themselves required to incorrectly define or describe themselves as married if they come to Scotland during the interim period. Amendment 2 is just a technical consequential of Amendment 1. And I'd like to conclude by again reiterating my thanks both to Tim Hopkins, the Equalities Network, for working with me on this, but also the Cabinet Secretary, who I think is of a mind with me on this. I'm grateful to her for her support.
Thank you. No members have indicated they wish to speak, so can I invite the Cabinet Secretary to speak to amendments in this group, please? Cabinet Secretary.
Thank you very much, and good morning, convener. I am pleased to support Alec Cole-Hamilton in amendments 1 and 2. Quite simple, but as the committee is well aware, they address a very serious point. Now, as Alec Cole-Hamilton said, Martin Lote from Eco Civil Partnerships gave evidence on this bill to committee, and he did express serious concerns about recognition of mixed-sex civil partnerships as marriage. In your stage 1 report, the committee concluded that there is no immediate alternative to the current approach, but did encourage me and the government to work with committee members to explore whether the language could be changed. As the committee may be aware, ultimately the demands of the COVID-19 work prevented Alec Cole-Hamilton and I from actually meeting on this issue, but it certainly hasn't stopped the work to take this forward. And in that case, I'm very pleased that I can welcome these amendments from him, and I'm pleased to support them. In line with the conclusions of the Stage 1 report, these amendments strike the right balance between addressing the concerns that have been raised whilst leaving the substance of the interim scheme of recognition intact. As the committee knows, recognition as marriage is about access to the full body of law that establishes rights, responsibilities and benefits for marriage. There is no equivalent body of law in place yet for mixed-sex civil partnership, and so there is a risk of loss or disadvantage if couples were to be recognised as a civil partnership before everything needed is in place. But I do absolutely recognise that couples will want to call themselves civil partners in day-to-day conversation, and these amendments reflect that. I absolutely recognise what Alec Cole-Hamilton and indeed other members of the committee have said previously, that we need to implement this bill as quickly as possible. Of course, there is a lot of work that we still need to do to ensure that that is done, and this will be impacted by how we need to work to tackle COVID-19. But I can assure the committee that this does absolutely remain the Scottish Government's priority to move these issues forward to ensure that the interim period is as short as possible. So I want to take the opportunity to reiterate my commitment to take forward the secondary legislation needed as soon as possible. I'll also work closely with the UK Government on the order under Section 104 of the Scotland Act on changes to reserved and UK legislation, and with the National Records on changes to IT and public-facing guidance and on training for registers. So I support Amendments 1 and 2.
Thank you, Cabinet Secretary. Can I invite Alex Cole-Hamilton to wind up and press or withdraw his amendments? Alex.
I've nothing further to add, convener, and I press the amendments.
Thank you. The question is that Amendment 1 be agreed to. If agreed, please stay silent. Any committee member who disagrees should type N in the Blue Jeans chat function now. No one has indicated disagreement, so Amendment 1 is agreed to. I call Amendment 2 in the name of Alex Cole-Hamilton, already debated with Amendment 1, and invite Alex Cole-Hamilton to move or not move. Alex.
Moved, convener.
The question is that Amendment 2 be agreed to. If agreed, please stay silent. Any committee member who disagrees should type N in the Blue Jeans chat function now. No one has indicated disagreement, so Amendment 2 is agreed to. I now call Amendment 10 in the name of the Cabinet Secretary, grouped with Amendment 11, and I invite the Cabinet Secretary to move Amendment 10 and speak to both amendments in the group. Cabinet Secretary.
Thank you, Convener. Amendment 10 responds to this committee's statement of support in the Stage 1 report for the principle of married couples, if they wish, being able to change their relationship to a civil partnership. This amendment would provide Scottish ministers with the power to make regulations on changing marriages to civil partnerships. This reflects what has been done for England and Wales and Northern Ireland, where similar powers are in place for the Secretary of State, albeit yet to be used. We will be taking forward regulations in Scotland to allow couples to change their marriages to civil partnerships as part of the suite of secondary legislation that will be needed to implement this bill if it is enacted. Our thinking is very much based on the existing arrangements which allow civil partners, if they wish, to change their relationship to marriage. In those cases, civil partners can choose whether to change their relationship by having a marriage ceremony, in much the same way as any other couple having a marriage ceremony, or by using an administrative route run by local authority registrars. We intend the same options would be available in relation to couples changing their marriage to a civil partnership. So couples would be able to register their civil partnership through the usual registration process, or would be able to use an administrative route. There are a number of reasons why a regulation-making power is appropriate here. First of all, the regulations will lay down the details of how the administrative route will work. Secondly, the regulations will make provision on the effect of changing a marriage to a civil partnership. As the committee knows, there are some complex issues which arise as part of changing marriages to civil partnerships. A general intention is that when a marriage changes to a civil partnership, the civil partnership will be treated as having been entered into when the marriage was entered into. However, marriage predates civil partnership in law, so we will need to be careful, and detailed provisions will be made on the treatment of marriages that are to change to a civil partnership for any period prior to the existence in law of civil partnership itself. This could, for example, be relevant if the couple should dissolve their relationship in identifying the property that's to be shared in the financial settlement. The use of regulations is appropriate when making highly technical provisions of this nature. Thirdly, use of a regulation-making power will provide an opportunity to consult as appropriate on provisions in this area. The powers require ministers to consult the Registrar General, which reflects that the Registrar General has operational functions in relation to the registration of civil partnerships and marriages. This will also allow us to take the views of local registrars about practical matters. Our intention is that the administrative route will be open to couples whose marriages were solemnised and registered in Scotland, in line with the existing arrangements for changing civil partnerships to marriages through the administrative route. This reflects that where details of the marriage are held on the registration system in Scotland, it is straightforward for those details to be used when the relationship is changed. Where the marriage was solemnised elsewhere, it will not have been recorded in Scotland, and as a result, our intention is that couples in a non-Scottish marriage who wish to change their relationship in Scotland could use the registration route. Again, this is in line with the existing approach to changing civil partnerships to marriages. The regulations also allow provision to be made on fees for changing marriages to civil partnerships. Our current thinking, again in line with changing civil partnerships to marriages, is that fees for the registration route will be the same as the fees normally payable on registering a civil partnership, and the fee for the administrative route will be the same as for submitting one notice of intention to enter a civil partnership. In both cases, there will also be charges for what are known as extracts, the civil partnership certificate. In short, we intend that the scheme for changing marriages to civil partnership is clear, fully considered, effective, and won't have unintended adverse consequences for a couple. Convener, I'd now like to turn to Amendment 11. This is about recognising in Scotland as civil partnerships marriages that convert to civil partnership in England and Wales and in Northern Ireland. The Civil Partnerships, Marriages and Deaths Registration etc. Act 2019 and the Northern Ireland Executive Formation etc. Act 2019 each provide the Secretary of State with the power to make regulations on converting marriages to civil partnerships for England and Wales and for Northern Ireland. However, neither set of regulations has been taken forward at this point. This means that we do not yet know how conversions in these two jurisdictions will work, but we do know that we want these conversions to be recognised in Scotland. For the purposes of recognition in Scots law, there are two key aspects that have to be taken into account: recognition of the relationships generally and backdating. The amendment reflects this by specifying two particular areas in relation to which the regulations can make provisions. The first area relates to registration. The Civil Partnership Act 2004 makes provision on what a civil partnership is. The effect of Section 1 is that a relationship formed in England, Wales or Northern Ireland is recognised as a civil partnership in Scotland, where the couple register as civil partners of each other under Part 2 or Part 4 of the 2004 Act. However, we don't know whether the schemes of conversions for the other parts of the UK will actually involve the couples registering as civil partners in line with Section 1. So this amendment specifically allows that Scottish ministers to make regulations that will ensure that converted relationships from other parts of the UK can be treated as registered under the 2004 Act. This means they will be treated as civil partnerships in Scotland. The second area is backdating. By backdating, I'm referring to the date that we treat the relationship in its converted form as having been created. Again, it's not clear what conversion schemes for other parts of the UK may do in this area, but we do need to be able to make provisions on backdating these relationships for the purposes of Scots law, and this amendment achieves that. More generally, it's important that we have flexibility around provisions on recognising converted relationships. Being prescriptive on the face of this bill could prevent these relationships from being recognised in Scotland in their converted form. Taking a power to make regulations will provide the tools we need to effectively legislate in Scots law in response to the final forms of conversion schemes for other parts of the UK. And I move Amendment 10.
Thank you, Cabinet Secretary. Alex Cole-Hamilton has indicated he wishes to make a contribution in this group. Alex.
Thank you again, Convener, and thank you to the Cabinet Secretary for that and for bringing forward these amendments. They're very similar, well, they have a similar effect to amendments I'd offered instructions to clerks draft in my name, so I'm very happy to support these. At stage one, several witnesses expressed concern that the bill lacks provision enabling couples who are already married to change their marriage to a civil partnership. Provision for change the other way already exists in the Marriage and Civil Partnership Scotland Act 2014. And it's clear there are some mixed-sex couples who have married who would have preferred a civil partnership if it had been available to them at the time. Similarly, it may be that a mixed-sex couple has become estranged from a faith under which they were originally married and wish to distance themselves from that institution. Same-sex couples who registered a civil partnership before marriage was available to them can change their civil partnership to marriage without losing the continuity of the relationship and its legal protections. Only that mixed-sex couples who have married before civil partnership becomes available to them should also be able to change. Given that a couple's preference for marriage or civil partnership is an intensely personal one and preferences differ, it would be discriminatory to allow change in one direction but not the other. Amendment 10 is therefore very welcome. It enables the government by regulation to provide for marriages to become civil partnerships. It is also welcome that the amendment allows that to be done in two ways, just as the changes with the changes in other direction. Those are by the couple registering a civil partnership in the usual way, or by administrative process, which will presumably only be available to those whose marriage is registered in Scotland. People's needs can change. For example, a couple in a mixed-sex civil partnership may join a religion that does not recognise a civil partnership and so wish then to change their civil partnership to a marriage. Equally, a couple in a same-sex marriage who join a religion who does not recognise same-sex marriage but does recognise same-sex civil partnership will wish to change their marriage to civil partnership. This could happen at any time in the future. It is therefore crucial that change in either direction, marriage to civil partnership or civil partnership to marriage, is available to both mixed-sex and same-sex couples and without a time limit. And it would be very helpful for the Cabinet Secretary could confirm that that is the intention of the government in terms of the time limit side of things. And one of the issues that has been raised is whether there should be a limit on the number of changes that can be made to one relationship. And the Equality Network have made representations to me to urge that if a limit is applied, it should allow at least for a couple to make 2 changes. For example, a mixed-sex couple may change their marriage to civil partnership after this bill comes into effect, because that is what they have always wanted. Years later, they may move to a country that does not recognise civil partnership, and so may need to find the need to change back to a marriage so that their family relationships are recognised in that country. Again, it's good to hear from the Cabinet Secretary what expected timetable is for regulations under Amendment 10. Amendment 11, I don't have much to say on that at all. It deals with civil partnerships that have been created by conversion from marriage in other parts of the UK. And absolutely welcome in my eyes. So I don't really have anything more to add to that, but just to thank again the Cabinet Secretary for bringing forward these amendments and assure her of my support.
Thank you. I invite the Cabinet Secretary to wind up, please. Cabinet Secretary.
Thank you, Convener. I don't really have much to say in winding up, but just to reiterate that we are not seeking to have a time limit on the conversion, so that it doesn't have to happen within a year, for example, and that part falls. There will be no time limit to that. And also to confirm that there's no limit to the number of changes. I do absolutely recognise that a couple's life together will involve evolving circumstances, changes in belief, social, family pressures that might lead them to change more than once. Ultimately, the regulations in this area will be informed by the principles that underpin the bill. That's about equality, freedom of choice, and that includes access to the best relationship for any given couple, which, as Mr Cole-Hamilton says, is a private matter for them, and the state should support them to be able to make the choice that's right for them.
Thank you, Cabinet Secretary. The question is that Amendment 10 be agreed to. Are we all agreed? If agreed, please stay silent. Any committee member who disagrees should type N in the Blue Jeans chat box now. No one has indicated disagreement, so Amendment 10 is agreed to. I call Amendment 11 in the name of the Cabinet Secretary, already debated with Amendment 10, and invite the Cabinet Secretary to move formally. Cabinet Secretary.
Moved, Convener.
Thank you. The question is that Amendment 10 be agreed to. Are we all agreed? If agreed, please stay silent. Any committee member who disagrees should type N in the chat box now. No one has indicated disagreement, so Amendment 11 is agreed to. The question is that sections 4 to 12 be agreed to. Are we all agreed? We are all agreed. I call Amendment 3 in the name of the Cabinet Secretary, grouped with Amendments 7, 8 and 9, and invite the Cabinet Secretary to move Amendment 3 and speak to all amendments in the group. Cabinet Secretary, please.
Thank you, Convener. There are a number of technical amendments in this group, so I hope the committee will bear with me as I go through them. Beginning with Amendment 3, this addresses a point made in written evidence submitted to the committee on the bill by the Faculty of Advocates about Section 3 of the Children's Scotland Act 1995. This presently provides that the mother of a child has parental responsibilities and rights, whether or not she is married to the father of that child. The bill already makes some amendments to the Children's Scotland Act 1995, including Section 3, to reflect that civil partnership will be available to mixed-sex couples. In particular, fathers at the moment obtain parental rights and responsibilities if married to the mother. The bill extends that to the cases where the father obtains PRRs if in the civil partnership with the mother. The faculty suggested a further amendment to Section 3 of the 1995 Act, stating that there should, for consistency, also be added the words "or entered into civil partnership with" before "his father," or alternatively the words "whether or not she is or has been married to his father" could simply be deleted. After consideration, we concluded that the addition of language would indeed provide helpful consistency. It will also provide clarity, putting it beyond doubt on the face of the legislation that the mother of a child has parental responsibilities and rights, whether or not married to or in a civil partnership with the father. This bill will extend that to cover cases where the father is in a civil partnership with the mother. The Scottish Government believes that generally children do benefit from both parents being involved in a child's life. However, there are some cases where the father is disinterested or where there has been domestic abuse or violence. Provision so that most fathers gain PRRs but a small minority do not reflects the realities we face. Turning to Amendment 7, this ensures parity of treatment for marriages and civil partnerships when it comes to the registration of court decrees that bring a relationship coming to an end. For marriages, Section 28A of the Registration of Births, Deaths and Marriages Scotland Act 1965 provides for decrees of dissolution and declarators of nullity to be registered in the Register of Divorcees kept by the Registrar General. However, the equivalent provision for civil partnerships to be found in Section 122 of the Civil Partnership Act 2004 provides only for decrees of dissolution to be registered in the Register of Dissolutions. There is no provision for the registration of declarators of nullity. Declarators of nullity are rare. The Justice statistics show that there are no more than 2 a year in relation to marriage and civil partnership, but they can be issued when one or both of the parties were not eligible to enter the relationship, or the parties were eligible but one or both of them did not consent to the formation of the relationship, or one of the parties who was capable of consenting to the relationship being formed did so only because of an error or duress. Our view is that declarators of nullity in relation to marriage and civil partnership should be treated in the same way. This amendment will achieve that parity of treatment in relation to registration by amending Section 122 of the 2004 Act so that the registration of dissolutions maintained by the Registrar General covers declarators of nullity of civil partnership as well. Amendment 8 makes provision on the jurisdiction of the Sheriff Court in relation to declarators of nullity of civil partnership. At present, only the Court of Session has jurisdiction to deal with court actions for declarators of nullity of civil partnership. The relevant provisions were put in place in 2004 when civil partnerships was established, and at that time this was also the position for declarators of nullity of marriage. However, things have now moved on in relation to the declarators of nullity of marriage, in relation to which either the Court of Session or the Sheriff Court can now have jurisdiction. Amendment 8 extends jurisdiction for hearing declarators of nullity of civil partnership to the Sheriff Court in line with the position in relation to marriage. Convener, the final amendment in this group, Amendment 9, changes a reference to same-sex in the Civil Partnership Act 2004 to reflect that mixed-sex civil partnerships will be introduced in Scotland. Section 237 of the Civil Partnership Act 2004 contains supplementary provisions on recognition of overseas dissolutions. More specifically, it provides that Scottish ministers with the power to make regulations that modify the normal rules on recognition of overseas dissolutions in the situation where a civil partner is domiciled in a jurisdiction that does not recognise legal relationships between two persons of the same sex. The same issue is liable to arise with mixed-sex civil partners. A civil partner in a mixed-sex relationship may not be able to obtain a dissolution where they're domiciled because the law of that country does not recognise mixed-sex relationships other than marriage. Accordingly, Section 237 requires amendment to make it possible for regulations to provide for a corresponding modification of the normal rules in that situation. This provides parity of treatment between same-sex and mixed-sex civil partners, and I move Amendment 3.
Thank you, Cabinet Secretary. No members have indicated a wish to contribute in this section. Cabinet Secretary, do you wish to say anything in winding up?
No, thank you, Convener.
Thank you. The question is that Amendment 3 be agreed to. Are we all agreed? If agreed, please stay silent. Any committee member who disagrees should type N in the Blue Jeans chat box now. No one has indicated disagreement, so Amendment 3 is agreed to. I call Amendment 4 in the name of the Cabinet Secretary, grouped with Amendments 5 and 6, and invite the Cabinet Secretary to move Amendment 4 and speak to all amendments in the group. Cabinet Secretary.
Thank you, Convener. Amendments 4, 5 and 6 in my name seek to replicate for the law of Scotland what was put in place for England and Wales at the end of last year and for Northern Ireland at the beginning of this year. The amendments make provisions in Scots law about the continuity of civil partnerships from elsewhere after one of the partners has obtained gender recognition. Like the existing provisions in this bill that touch on gender recognition, I stress that these amendments do not constitute a change in policy on gender recognition. Rather, they reflect that civil partnership is no longer solely a same-sex relationship elsewhere, and that it is appropriate for provision to be made in Scots law reflecting this in the context of gender recognition. At present, Section 11D of the Gender Recognition Act 2004, the GRA, provides for the continuity of a Scottish civil partnership where both parties to the relationship acquire a legal change of gender on the same day. This reference to both parties reflects that civil partnership is currently a same-sex relationship and there is no recognition of a mixed-sex partnership. As a consequence of the introduction of mixed-sex civil partnership, paragraph 514 of Schedule 2 of the Bill makes provision on the continuity of a civil partnership formed in Scotland where just one party to the relationship acquires a legal change of gender. In paragraph 97 of the Stage 1 report, this committee welcomed the provision saying that the committee welcomes the provision in Schedule 2, paragraph 5 of the Bill to the extent that it benefits transgender people who wish to remain in the formalised relationships they entered into prior to transition. Section 11B of the GRA makes provision on the continuity of civil partnerships from elsewhere in the UK and from Northern Ireland. Section 11B has already been amended by UK legislation to reflect the introduction of mixed-sex civil partnership elsewhere in the UK. However, the amendments by UK legislation do not extend to Scotland. So Amendment 4 provides the partnerships from other parts of the UK and civil partnerships formed elsewhere, which are recognised in Scotland, can continue in Scots law if one party to the relationship obtains a legal change of gender. Amendments 5 and 6 are consequential. Amendment 6 adds a definition of protected civil partnership into the GRA. This is defined as meaning a civil partnership under the law of England and Wales and Northern Ireland, or an overseas relationship that is treated as a civil partnership. Amendment 6 also adds a definition of protected overseas relationship to the GRA. This is a protected civil partnership from overseas. These terms are both used in Amendment 4. Amendment 5 is simply a formatting change linked to Amendment 6, and I move Amendment 4.
Thank you. No other member has indicated they wish to speak to these amendments. Do you wish to say anything in winding up, Cabinet Secretary?
No, thank you, Convener.
Thank you. The question is that Amendment 4 be agreed to. Are we all agreed? If agreed, please stay silent. Any committee member who disagrees should type N in the chat box now. No one has indicated disagreement, so Amendment 4 is agreed to. All amendments 5, 6, 7, 8 and 9, all in the name of the Cabinet Secretary and all previously debated, and invite Minister to move amendments 5 to 9 en bloc, please.
Moved en bloc, Convener.
Does any member object to a single question being put on amendments 5 to 9? Committee agrees. No one's indicated disagreement. The question is that amendments 5 to 9 are agreed to. Are we all agreed? If agreed, please stay silent. Any committee member who objects should type N in the Blue Jeans chat box now. No one has indicated disagreement, so amendments 5 to 9 are agreed to. The question is that Schedule 2 be agreed to. Are we all agreed? Committee is in agreement. The question is that Sections 13 to 15 be agreed to. Are we all agreed? We are all in agreement. And the question is that the long title be agreed to. Are we all agreed? The committee agrees. And that ends stage 2 consideration of this bill. Can I thank the Cabinet Secretary and her officials and remind members that stage 3 of the Civil Partnership Scotland Bill is scheduled to take place on Tuesday 23rd of June. The deadline for amendments to the bill will be Tuesday the 16th of June. The committee will next meet on Thursday the 18th of June, where it will hear further evidence on our inquiry into the impact of COVID-19 on equalities and human rights. I'll now close the meeting. Thank you.